Well, with this U.S. Supreme Court ruling, it's as Dawn was saying, the fight far from over. It's now a battle that the Supreme Court is sending to individual states to decide upon. For more on this, we can now cross to at this point in time. Our next guest, Stephen Dreyfuss, the former president of the International Association of Lawyers. Thank you for speaking with us here on France 24.
Happy to be with you. Thank you.
Let's first examine the central argument in this, which is it's not a law that's being struck down as such, since no legislation was ever passed at the federal level. The Supreme Court effectively saying, if you want abortion to be legal across the United States, Congress has to pass a law. Do you agree with that?
Well, I think you're looking at it from the opposite view. The question is not so much that Congress has to pass a law. That Congress certainly could, but the opinion of Justice Alito is focused on the fact that the states have the right to legislate in this area in the absence of congressional legislation rather than the courts. So what he's saying is we leave it to the democratic process in each state to decide whether or not abortion should be legal. And the analysis is basically that it's an interesting comparison with the gun rights case that was decided yesterday. In that case, the court said that because the right to carry a gun, they say, is in the Constitution, in the Second Amendment, the states cannot impose unreasonable conditions on that right and must give law-abiding citizens the right to carry a gun. Here, because they say that the right to abortion was erroneously found to be in the Constitution by the Roe Court and the Casey Court, they're saying that it's up to the states to legislate in that area, and the Constitution does not provide a right to women to obtain an abortion. So and both of those analyses are based on the court's historical perspective. So we have the unusual situation, and the very disturbing one to many in this country, that the availability of an abortion to women in 2022 and forward is going to be determined by what the founding fathers had in their minds in the 18th century and what the country was doing in the 19th century. And that seems fundamentally wrong to many people in this country, but that is the direction that the court is going in both of those cases, saying that history and tradition determine whether there is a constitutional right or not.
I want to ask you more about this legal, the way it's dressed up legally. But first, again, I'll put the same question we put to our previous guest. She pointed out how a majority of Americans are for a woman's right to choose, yet this ruling comes down. Why is that?
Well, it's because we have a fundamentally conservative Supreme Court, and it comes down to the saying in American politics that elections have consequences. And one of the major consequences of the election of Donald Trump was the appointment of 3 conservative justices to the Supreme Court. And you notice that both of these decisions have come down 6-3 with the same majorities. There have been second opinions and concurring opinions in various cases, but basically we have a situation in which the court now is skewed to the right. The concern is that regardless of the views of the people on this particular issue, this is the analysis that a court composed of conservative justices has made. If people feel very strongly about the right to abortion, according to the court, they can exercise their political power within each state to convince the state legislature to permit abortion. But the court is not going to do it as a nationwide matter of constitutional law. The court is not going to legislate. It's going to leave that to the legislatures of the states to do.
They're going to leave it to the legislatures, but what if you drive a person across a state for an abortion? Will that be a federal issue? What if you give them abortion pills that are produced in a different state?
Exactly right. And those cases have yet to be decided. There are state laws that have been passed recently that will criminalize the activity of an American doctor in New York for sending abortion pills to somebody in Texas. That implicates a different provision of the Constitution, which is the right of the federal government to regulate interstate commerce. So the question will be whether a law like that infringes on the freedom to conduct interstate commerce and might be argued to be unconstitutional in that regard because of the crossing of state lines element. But the problem here is that we now have a situation in this country where we are only looking at the question of abortion from the point of view of the fetus and not from the point of view of the woman. And that is really the fundamental disconnect here. Because if you look at abortion as a medical procedure that is undertaken between a woman and her doctor for the purpose of dealing with her health, then there is clearly lots of authority for the idea that the government should not interfere in that decision, nor force a woman to undergo a medical condition that she decides she doesn't want to undergo. On the other hand, if, as the court has done, you take the point of view of the fetus and say the fetus has a right to life and it's up to the states to decide whether or not they want to allow a woman to interfere with the fetus's right to life, you're putting the right of the fetus above that of the woman. That's a policy judgment which the court is saying the states have to make, but indeed the Supreme Court now implicitly is making that policy judgment and saying that a woman's right does not prevail over the right of the unborn child.
Stephen Dreyfuss, former president of the International Association of Lawyers, thank you for speaking with us.
Thank you very much.